good morning, everybody. Welcome back to the ROS Media channel. My name's Andy. I am the person who heads up the ROS Media channel, and I'm here again with my good friend Ian Clifford. If you don't know who Ian is the founder and the president of the Republic of Old Souls, responsible for all of our protocols, in particular our flagship protocol, the Monopoly Game Changer. But what we're here today to talk about is last Saturday's webinar. Ian and I ran a webinar on Saturday the 20th of June, as we do every single week between myself and Sims. We alternate weeks on those webinars with Ian as the host. And then Ian covers different subjects that are very, very pertinent to where we are at in today's world, particularly within the economic situation that people find themselves in. You know, the cost of living crisis, mortgages crippling people with payments. And it was mortgages that we spoke about on Saturday. So what we did was we collated all the questions that you guys put together at registration point and also in the chat on the webinar. And we're going to answer those questions, or the outstanding questions that we didn't get around to dealing with on Saturday. We're going to do that today. Okay. So we've got 4 different categories, Ian, to go through in terms of the questions. As far as the actual mortgage side of things itself, do you want to just give the audience a brief overview of what we discussed, and that will maybe give them some context over where these questions are coming from?
Yeah, I mean, it's how do you discharge a mortgage without actually sending a payment to the mortgage provider to pay off the mortgage. What I outlined on the webinar was the fact that the mortgage itself is just a ledger, really. It's a credit and debit ledger, and the credit was provided to the bank from a promise to pay that the borrower deposited with the bank that issued the mortgage. So the mortgage sprang into existence from a deposit of human energy, which is the promise to pay. And then what the bank did is it sold that promise to pay as a security to an investment bank who hold on to it as if it's theirs as a nominee, and they use it and hypothecate it and make profit from it. But they are not the creditors, but they are never challenged. So the presumption is that they are creditors, and the original bank that gave the mortgage or that created the mortgage from the deposit of the energy, they become the servicing agent to collect the mortgage installments. But the problem is that they get a charge over the property.
Yeah.
So that if you dispute that the mortgage was generated, or you dispute that they didn't lend you money, or you say, hey, I deposited the credit with you and therefore there isn't a valid mortgage at law, no judge anywhere in any courtroom is going to uphold that argument, because the judges are there to protect the mortgage system. So that challenge never works, because it's too low down in the system, and it's because there's a charge on the property that that's all the judges care about. They don't care about how the mortgage was created. They just care about, is there a mortgage charge on this property, yes or no? If the answer is yes, then the mortgage, or that's the alleged borrower, has to pay the mortgage off or pay the interest. And if they don't, well, hey, guess what? The mortgage provider takes the property back. So that's the problem at the local level. But so what I was describing and outlining on the webinar on Saturday was, well, how do you correct the ledger? Because the ledger is being created, and the investment bank that's holding the security is presuming that they are the creditors to the mortgage. Well, they're not. So if you create a nominee structure, which is a foreign grantor's trust, file having realized where the mortgage is, where the mortgage security is, you've got the CUSIP number, which is the securities reference number. You know which investment bank indentured trustees holding the mortgage security, you know where it is, and you also know that they're paying tax for the use of the of the deposited energy, and that is the big giveaway. So you create a foreign grantors trust. The foreign grantors trust files a 1099 OID, which then corrects the ledger, actually balances the ledger, because the foreign grantors trust becomes the creditor. As soon as it becomes the creditor, then the debt has been discharged, and there is no more mortgage. It's been discharged at the top of the ledger. And then what you can do is you can put the indentured trustee, that's the investment bank, on notice through something called an adverse claim. You can then take them into the Southern District of New York court as a defendant, because they should discharge the mortgage and remove the charge, but they haven't so far. So you can get a federal judge to look at the case, look at the forensic evidence, and my guess is that most investment banks will privately settle, because they don't want to have a public Southern District of New York court judgment that says that they never were the mortgage creditor. And that would mean that all of the other investment banks are not mortgage creditors either, which the investment banks and the clearing banks really don't want that information to be out there, A, but B, they definitely don't want a court decision that clarifies and confirms that they never were the creditors in the first place.
Yeah.
So that would be really bad news for the banking market. So my guess is that the mortgage indentured trustees, which is the investment banks, having forensically proven that they never were the creditors, and now they definitely aren't, because the 1099 OID, the fact that they've been paying taxes on the mortgage, the fact that you can evidence that they are holding the mortgage security under a street name, the fact that you can evidence that the original charge was never really recorded correctly, because the lending bank, or so-called lending bank, never really had the credentials to take the charge in the first place. So you can get the charge removed because the mortgage has been discharged at the top of the ledger. There is a registration gap which you can also bring into this. But basically, if you discharge the mortgage at the top of the ledger, then it's no different from sending fiat currency to the mortgage provider and discharging it that way. You're just doing it a different way that doesn't cost you 25 years of sweat, toil, and labour to do it.
Gotcha.
And that's what I described. Yeah.
And
then, of course, what you also get is the face value of the mortgage. You're redirecting the taxes equal to the face value of the mortgage through the 1099 OID, foreign grantor trust, receiving that face value. So even if you didn't get a private settlement, you are going to get the face value of the mortgage, the taxes redirected to your foreign grantors trust. So you could discharge it with fiat currency if you didn't get a private settlement or a judgment.
Right. Okay.
So you can't lose.
Well, let's dig into the questions, Ian, because we've had quite a few. The first category is to do with just the mechanics of that, the securitization mechanics, just, sort of accounting standards and the institutions that are involved. And the first question that we've had is, does a UK mortgage securitization always void a mortgage? What are the levels of securitization? And what's the difference between banks and building societies concerning UK mortgage securitization?
Well, some good questions. Every mortgage is different. Sometimes there's only two players, the mortgage provider and the investment bank indentured trustee. And what they do is they hold the mortgage security at seed and company, which is part of the deposit trust company. So there can be just two. I've looked at one recently where there's four. There's a clearing bank. There's three other banks involved. They sort of selling the securities on in a chain until it ends up in a indentured trustee in New York. And the reason why it always ends up there is because that's where they pay the taxes for the use of the energy. They always pay them from an investment bank in New York. So somewhere along the way, by the end of its destination, the mortgage security is going to end up in an investment bank's 945 tax ledger from New York. Is every single one I've looked at. So is it any different with a building society? No, because the building societies create the mortgage in the same way as the clearing banks. They securitize them in the same way. It's the same model. The building societies have got a great story that, they're a cooperative and they take savings in and they lend them out. It's a fantastic story. I was watching a advert not long ago. I didn't want to watch it, but it came on in the middle of a program I was watching, and they're saying, we're a cooperative and we're giving £100 back to all of our members, because it's like a club, like a friendly society club, but they provide mortgages exactly the same way as the banks do. No different. Their constitution's different, but their mortgage creation next Nelio Credit is exactly the same. They don't lend out savers money. That's a myth. No, just like the banks don't lend out savers money. That's not to say that they don't operate differently, because they do operate differently, but not in mortgages. It's the same model. It's too profitable for them not to operate in the same way as the banks do. So,
gotcha. Okay. So that answers that one. Thank you. Next question on this category is, if a bank issued mortgages which were sold on after they collapsed, will this information be available to track to show the new mortgage holder?
Yeah, banks come and go, but the securities don't. They always stay there. So once a bank has created the security, sold it on, then that security is going to stay in operation. It's going to be held by an investment bank somewhere in New York. And even if they get into trouble, which is highly unlikely, all the securities just get moved on into another investment bank. So the securities don't go away. It's like the debt doesn't go away. Can you imagine if a bank went bust, all the debt the bank had issued all goes with it? No, they just sell it on. So the debt always stays there. The bank might come and go, but the debt always stays there. That's because that's part of the model.
Okay. Excellent. Let's move on to section number 2 then, which is to do with the trusts. So the 98 series foreign guarantor trusts, and then different tax jurisdictions as well. The first question, Ian, is why specifically use a 98 foreign guarantor trust from the IRS Cincinnati International Unit to discharge a mortgage? Why not IRS Chicago branch or somewhere else?
Well, they only issue the EINs from one IRS office, which is Cincinnati. Mm-hmm. They don't issue them anywhere else, and they are foreign grantor trusts. So if you try and get one from Ogden, for example, which is another one of their offices, or anywhere else, because they've got multiple offices around the US, you're not going to get a 98 series foreign grantor trust. You might get a domestic trust, but you're not going to get a foreign grantor's trust.
All right. So that is specific to the Cincinnati office. Okay.
It's a very specialized trust EIN, which is why they don't like giving it out, and it only comes from one place. I mean, if you look at all the tracking and tracing that the IRS does, they know if they see a reference number, an EIN from Cincinnati, they know that that's probably a foreign grantor's trust.
Gotcha. Okay, next question. Are bank deposits also able to be placed on a 1099 OID? And does a person need to file a UCC1 statement with the foreign grantor trust as a secured party?
Well, deposits are securities, but they are securities for the issuer, not the receiver.
Yes.
So if you are the receiver and you've got what appears to be money in your account, unless you created it through your ex nihilo signature, then you're not you're not the creator of it. You're not the originator of the ex nihilo credit signature.
No.
So you have to send it out of the account for it to qualify, which is, it sounds weird, doesn't it? You think, well, I've got $100,000 in my account, surely I can recoup that. Well, it's only when you spend it out of your account that you can recoup it. You've got to send it out, because then now you're issuing new negotiable instruments to the value of the account balance. So that's how the game works, you see. If you don't have any units in your account and don't have an overdraft, you can't send any credit out, can you? No. So that's all part of the slavery model. Just imagine if you could get a bank account and they said, yeah, don't worry about anything coming in, just spend going out. And everyone would have a really good time with that, wouldn't they?
How easy that would be, yeah.
That wouldn't be much of a slavery model, would it, if you had it like that? So you have to have the units in your account, which is your limitation of what you can send out. So that keeps the river flowing, yeah? It keeps the currency river flowing. You're going to have flow coming in, flow going out, all that economic activity, that slavery model is moving all the time. Yeah. So that's how it works. And could you send money from a savings account to a current account, for example? That wouldn't qualify either. So that's just to make that clear, because the savings account doesn't do ex nihilo credit.
No.
Only current accounts do. So you've got to put it in a current or checking account, as they call it in the US, and send it out there, because that type of account is now issuing the negotiable instruments.
Gotcha. So it's got to be a transactional account, checking account, something where you can do direct debits from, that type of thing. That's the type of account. And then the simple answer to the other question is it's money out, not money in.
It's money out, not money in. You don't get anything for money in.
No.
You get everything for money out, because when you issue, you've got to imagine you're issuing a new negotiable instrument when you're sending out. But when you're receiving, you're not issuing anything. No. Somebody else is issuing the negotiable instrument to you.
Yeah. Okay. All right. Next question is there any way not to get the tax redirected? And I think what this question is, what if this doesn't work? That's the way I'm reading this. Okay. Is there any way not to get the tax redirected and avoid losing out on any donations?
Well, anything's possible. I mean, in theory, suddenly the investment bank that you have got that have been holding your securities and paying taxes suddenly goes bust. The year before your claim goes in, so you suddenly those taxes have to be moved to another investment bank, and you've already put your claim in, and you've got a crossover. I can't even imagine that to happen, because the investment banks that are paying the 945 taxes, they don't go bust. No. They don't, because the United States Treasury, they're in the club that is fueling the United States Treasury with the taxes, so they're unlikely to go bust. I'm trying to think of a situation where it could happen. It could be a war, I suppose. It could be a war and the IRS closes down. That can happen.
Yeah.
It could all be put on hold because of a war. That's about the only thing I can think of, really.
Yeah.
Is that the IRS just closes down, all their processes stop. The entire US government could go on strike, which has happened before.
Yeah.
Including all the IRS, but that's again highly unlikely, because the money system has to keep running, and I think it's going to be one of the last things they turn off, because they're using it to track and trace people. So
exactly,
I don't think they're going to turn it off for me.
No,
not for my the way I see it. So I can't really think of anything that is in the ordinary course of events. Extraordinary things can happen. A nuclear bomb could drop on the United States, I guess, and obliterate half the country. that might stop it. Things of that type. A meteor could come out of outer space and crash into the Earth. Something like that could happen. Anything could happen, really, couldn't it? There could be a load of aliens arriving. I've been listening to a lot of interviews about aliens recently, and all the disclosures, all these different governments saying, well, we didn't want to tell you, but we've been talking to the aliens. So maybe there's an alien invasion that could happen. Who knows? But
okay,
who knows?
Let's move on to the next section then, which is to do with foreclosures, repossessions, and debt settling as well. So questions here. If a house was repossessed due to non-payment of a mortgage or the interest, can we still go after the indentured trustee in court? Does the security still exist?
If the mortgage is being discharged through foreclosure, then you can't go after the indentured trustee to release the charge, because the charge has already been released.
Yeah.
So you can't catch the horse after it's bolted. It's already left the stable. It's gone. It's too late. If it's pre-foreclosure, yeah, you could. And if you had enough time, you can discharge the mortgage at the top of the ledger, and that could stop a foreclosure. I don't want people to think that that's an easy thing to do, because it isn't. And you have to have enough time to get the mortgage discharged at the top of the ledger. But yeah, it can be done if you've got time. If you can stall the foreclosure, or you've got many, many months to discharge the mortgage at the top of the ledger, then it can actually happen. But
okay,
after a foreclosure has happened, no, your remedy there is to redirect the taxes on the face value of the mortgage.
Yeah.
So that doesn't matter, because that you have a right to that tax redirection, whether the mortgage is being discharged or not. You've still got the tax redirection that you can look forward to. So that's what I would be doing if I was in your shoes, if the mortgage was foreclosed on.
Yeah.
Already.
Okay. Next question. In settling any so-called debt, be it a credit card or a mortgage, should one notify the credit agencies and demand a receipt above and beyond proof of delivery via post office or courier? Furthermore, what happens if someone wants to sell the property after executing this?
Should you notify the credit agency? It probably would be a good idea to say the mortgage has been discharged, and remove it from the register, because the bank probably won't do that.
No,
because that's what they normally do. Is they normally tell the credit agency that the mortgage has been paid off. Well, if you're discharging it at the top of the ledger and getting it removed from the charges register in the local country, then yeah, the bank may not tell the credit agency. So it's probably worth telling them. Is it going to affect the credit score? Probably, because it's still a debt discharge, so it should increase the credit score. What was the second part of the question? I've forgotten.
The second part was, what happens if somebody wants to sell the property after doing that?
Oh, yeah, well, it's no different. You've discharged the mortgage.
Yeah.
So there's no mortgage charge. You can sell the property.
Yeah.
And like in exactly the same way as if you sent fiat currency to discharge the mortgage. You've actually done that, but all you've done is use a different way of doing it. You've done it through a ledger correction. The 1099 OID has what it's done. If you look at the Bills of Exchange Act, you've got the payer and the payor, and what you've done is you've merged them together under the Foreign Grantors Trust. So you've got the ledgers, you've got the debt on one side, you've got the credit on the other side, and what you've done is that you've collapsed the ledger through filing the 1099 OID. That's what you've done. And when you send, if you've got a debt here and you send them fiat currency, that's what they do. If you send them fiat currency, you've done the same thing. You've just done it in a different way.
Yeah. Okay. So here's another question. This is more to do with a personal situation that somebody is obviously finding themselves in. They've put my buy-to-let properties have already been taken into receivership by third-party agents who are systematically removing tenants in order to sell them off to clear the mortgages. How can this process enable me to stop this from happening, force them to back off, and compel them to refund all the charges they've added?
Well, if they've taken the properties into some kind of custody or some, however they've done that with a court order or somehow, then if you discharge all the mortgages, they don't have the right to carry on doing that. And yeah, if they've done up until that point, the mortgage was discharged, they probably argue that they've got some kind of right to charge things. But after the mortgages have been discharged, they haven't got any rights at all. They've gone. They're out of the equation. So yeah, in a scenario like that, I mean, if you look at the landlord problem, I presented this a few weeks ago on a webinar. The landlord problem is that they've got no way of setting the interest, the cost of interest, the rent against the interest on the mortgages. So they can't do that anymore. So if you get rid of the debt, there's no interest, and then your property portfolio still works.
Yeah, yeah.
So for landlords to discharge all the mortgages is absolutely something that I believe they should be doing.
Yeah, absolutely. Okay, let's move on to the final section, Ian, which is now to do with timelines, historical reach, lifetime mortgages. First question is, how would I discharge a lifetime mortgage if I hadn't actually made any active interest payments to the provider during its term? Would I simply claim back the compound interest which has been accumulated over the years it's been in existence?
No, it's much better than that, actually, because the lifetime mortgage is just rolling the debt up. It's just rolling the interest into the debt. And the face value of the debt is going up and up and up. So when you discharge it at the top of the ledger, whatever the current balance is, that's what you're discharging. The mortgage is gone. Mortgage is discharged, and then you redirect the taxes at the peak of the mortgage value, which is probably the current value, because they never go down, they always only ever go up in exponentially. They go up and up and up, those lifetime mortgages. So yeah, it doesn't matter whether you paid them or not. In reality, you have paid, because they've been taking equity out of the property. The debt is got bigger, so that you have paid them, but you've paid them through sacrificing the net equity of the property. That's what's happened. So.
Okay.
Yeah, I mean, for those scenarios, it would be, because eventually you run out of equity on those, and then at the end you end up living in the property and there's hardly any equity left. That's basically the trajectory of all of those lifetime mortgages. Eventually, there'll be no equity or hardly any equity left.
Yeah. Okay. But if the balance goes up, then in this scenario, that's a good thing, not a bad thing.
Yeah, you discharge the mortgage at the current value, wherever the value is, and then you redirect the taxes on that value. Yeah. So yeah, I mean, if you've already had cash out, because that's what the lifetime mortgages tend to do, they give you cash up front, they roll the mortgage debt up, and then you get to stay in the property. Well, you've already had some cash out. You're going to discharge the entire mortgage, and then you're going to redirect the taxes on the face value of the mortgage. So you kind of get 3 bites of the same cherry. It's a pretty good deal, I think.
Yeah, it is. Okay, next question is, how far back can an individual go with this protocol? For instance, if a member is now 69 years old, can they track back to their first mortgage and loans from 1980, 1981?
Maybe. Don't know without knowing which mortgage provider it was. Mortgage securitization came in the sort of mid to late 80s, strangely enough, around the time of the massive interest rate hikes that I remember very, very well in 1987, around that sort of time. Cost of mortgages were going through the roof. I had 3 mortgages at the time, so I remember it very well.
Yep.
And I was in the early phase of my business, so it was quite a tough time. Suddenly the interest rate went up to 16%, and they were securitizing mortgages back then. So maybe we'd have to look at it, really. We'd have to see if we can find the mortgage and the mortgage security, and it may well, believe it or not, that mortgage security may still be running, because they run for a long time.
Yeah. Okay. Right. Final question, Ian. What is the time period for the void process? And how will we know exactly when it happens on the public ledger?
Right, great question. First of all, you've got to create a foreign grantor's trust. Now, if you're already doing signature credit tax redirection, you'd already have one.
Yeah.
But if, let's suppose you don't have one already, then that can take a month to get on average, it could take, let's just say it's a month. Then you file, your foreign grantor's trust files the 1099 OID. We would have had to have run a securitization and discharge report to track the mortgage security, indentured trustee, and all of those references and linkages in the 945 tax module. We'd have to link all that up in a report. That report basically becomes the foundation of your case against the indentured trustee and ultimately the mortgage provider. So that can be run when you first start, actually. You don't actually need the 1099 OID in the foreign grantor's trust to run the report. In fact, it's better to run the report before you file the 1099 OID, because you've got to make sure you're filing the 1099 OID against the right indentured trustee. So run the report, get the foreign grantor's trust, file the 1099 OID. Then you file something called adverse claim, which is you're putting the indentured trustee and the mortgage provider on notice that your grantor trust is an interest in the mortgage security, and if they basically do something with it, that they can't sell it on or collapse it or hide it, because if they do, they'll be in breach of the Indentured Trustee Act of 1939, and they don't want to be doing things like that. And then you file suit against them in Southern District of New York. You file a claim. You enclose your forensic report that's got all the evidence of the mortgage being discharged.
Yeah.
You file what's called a memorandum of law, which is heavyweight with a load of technical references in it that justify what's happened, and then you wait for a defence to come in. So the mortgage provider, the indentured trustee, invariably will defend it. They'll send a defence in. That defence is provided to Ecclesia Law, who writes a forensic report on defence. You then can respond to the defence because you'll have the forensic response, which is not legal advice, it's just a report, forensic report. You serve that. And then what probably will happen is, if the mortgage indentured trustee realizes that if that goes to a paper hearing, because you're not going to stand up in the courtroom, it's highly unlikely that you'll be appearing in any court process or hearing. It's all going to be done on the papers. Then a judge might say that they want a final defence from the indentured trustee, which if they, you filed your case, they filed a defence, you filed your counter to their defence. The judge might say, look, we're going to give the bank one more go at defence, and then they're going to make a decision, the judges. Now it's that last leg where, in my opinion, and I've seen this happen, the investment bank is more than likely going to want to privately settle. So you offer them a private settlement opportunity, which is done off the books. It's not part of the public record. The bank can't claim it. They can't say, hey, the plaintiff offered us a private settlement, because it is private. and there is a mechanism for private settlement. And it's my opinion that the majority of the investment banks will want to privately settle it, because they won't want to run the risk of a judge deciding against them. Because if that happens, every other law firm, every indentured trustee is watching that case, is going, please don't let this go to trial and go all the way to the decision, because we don't want an adverse decision against the investment bank market. So it's my view. It'd be interesting to see. We'll know very soon. And let's suppose the worst possible thing happened, right? And the judge, the investment bank didn't privately settle, and the judge, which is in the First Circuit, decides against the plaintiff.
Okay.
Well, if that were to happen, that would go straight to, if I was running that case, if it was my case, I'd be taking that straight to appeal.
Yep.
And the investment bank will know that it's likely to go straight to appeal, because the judge would have already looked at the case at the beginning, you see? And if there's absolutely no merit in the case, they blow it out, they strike them out straight away. So if it's got through the first hurdle, the judge has already looked at it, and they've already thought, there might be some merit in this case.
Merit,
If there is some merit and it gets all the way through, and then the judge decides against the plaintiff, the mortgage or the alleged borrower, then you almost certainly would have a grounds for appeal.
Yeah. Okay.
So I did a whole risk analysis. I used AI actually to do a risk analysis on the probability of private settlement, and it came out at 85 to 90%.
Wow.
Remember, AI doesn't like anything outside of the ordinary, so it's for it to say there was an 85% to 90% probability of an investment bank settling privately was quite revealing of the fact that it's a very powerful process.
Yeah. Okay.
AI would normally say, this has got no merit. This is pseudo law nonsense. Are you being serious? No judge in the world is going to uphold this. No, it came back and said that because you do something called game theory, which is all about probabilities of what's the strength and weakness of each side of an argument or a case, and the AI can do that. And if it doesn't think that your plaintiff side of the case is very strong, it's going to say that straight away. Come up and say that's a load of nonsense. You're going to lose. Go and get some legal advice. It'll probably tell you, but it doesn't say that. When I ran the test, so I was quite interested by that.
That is interesting. It is. So clearly, it's not an overnight thing. There's toing and froing with this. It's going to take some time. You said about a month on average.
Yeah, I could guess. You could take a month before you've got your 1099 OID. You've got a couple of weeks for your adverse claim. You've then got your claim papers to go into Southern District of New York. They probably take a week, 2 weeks to look at them. If they accept the case, which they should do, then you've got the defense. So you've got maybe a month for the investment bank to make a defense. So now you're up to like 2-3 months. Then you might have another month before you get a private settlement. I reckon 6 months is a reasonable time frame. That's my guess, about 6 months.
Okay. And how would the individual know exactly when that's happened on the ledger?
Well, because you see the case is if you file it and it goes on something called PACER, which is electronic record of the case, and every time the investment bank lawyers post something, it goes on PACER, and you can see that. So you can actually track your own case, and we'll be launching an avatar that will give you an insight into what's going on with anything that's happening. So you'll be able to ask the avatar, and if you want forensic research done on any step, then you can, as part of the process, you can invoke your right to have ecclesia law, forensically research whatever's coming out of the investment bank's lawyers, not giving you advice, just saying this is what it is, this is what it means, and this is what you can say in response. But they're not giving you advice to say anything. You can do and say what you want. But it's just like going down the library and saying the bank says this. I want to find that in the law in the law books. What do I say in exchange? Or if you did it with your own AI, you plug it into your own AI and say, hey, the bank said this. What do I say in exchange? It's just like that. We're just using a research facility as opposed to a law firm that will give you their advice. Well, we're not going to give any advice. We're just going to give you a forensic response based on research, which is no different from going down the library or doing an internet search or doing an AI search.
Okay. Well, that concludes all the questions, Ian. And I think, what we've covered today clearly points to the fact that the financial system as we know it runs on a very complex system of ledgers that people aren't really understanding in the right way. The average person's never taught this. They don't read about this. But understanding what your signature credit energy actually does is certainly half the battle. But you need to understand how to then leverage that in the right way with the right structures, the right types of filings. We're going to be talking a little bit more about this on this coming Saturday as well. So I thought that no better time than right now to talk a little bit about Saturday the 27th webinar, which is to do with the birth certificate. There's a lot of widespread belief within the freedom, sovereign-based communities and circles that the birth certificate is some kind of bond that you can cash in, some kind of secret trust that has this huge cash value to it. But there's some real dangers, and we've already spoken about this before. If someone attempts to try and draw these funds from this non-existent account or use it to offset charges, loans, mortgages, whatever it may be, and the reason that that's dangerous for people is because something else within the system, which is the law of agency, which people often feel that this agency trap is a real curse. But what Ian's going to talk about on Saturday is how the actual agency to the birth certificate construct could enable you to redirect up to 50 million, if not more, over your lifetime from where you're at now of signature credit taxes. So while some people deem it to be a curse, and they're actually trying to actively separate themselves from the birth certificate construct, and then you've got other people that think it's this secret trust fund that's got millions of dollars in there that they can access, what we're saying is it's actually a doorway to signature credit tax redirection. And if you know how to do that properly, then the agency is not necessarily a curse, but actually a blessing in disguise. You've just got to know how to frame it, how to structure that. So if you want to learn more about that, maybe you're somebody that's been watching videos about the birth certificate. Maybe you are one of those people who genuinely feels that it is a secret trust. Ian's going to uncover a little bit more detail on what the birth certificate construct actually is, but how you can use it to your advantage, so that you wouldn't need some secret trust somewhere, because it has the ability and the capacity to generate tax redirection now and every year moving forwards. So really, really excited about Saturday's webinar. If you want to join us, we do it every weekend, every Saturday morning, same time, 10 a.m. If you want to register for that, you can go here. You can go to roswebinars.is and you can register for the webinar. You'll be able to register from your platform if you are a member here at the Republic of Old Souls. If you want to learn more about Ian's research on this, and Ian does very, very deep research, then you can go to ecclesialaw.is and you can see all the reports, not just the one to do with Saturday's webinar, but also previous webinars that we've done, all the technical data and the technical reports surrounding mortgages, surrounding signature credit tax redirection, anything you would like to know about the trust structures, the 98 series grantor trusts, the 508c1a trusts. It's all there for you to read, and I would highly recommend you do that. If you prefer to watch my ugly mug, and Ian on these particular webinars, then you're more than welcome to go to our media platform and see more of the same, where we've broken all of those technical reports down and we cover them step by step by step, every inch of the way, going very, very deep, sometimes very technical on the what, the how, the whys of all of these protocols that Ian's put together. But if you really want to take some decisive action and learn more about it on Saturday, then we would encourage you to come to the webinar Saturday morning. We always have more registrations than we have seats for, so just be mindful of that, guys. We only have 1,000 capacity on the webinars, and we always get more than 1,000 people registering for those webinars, typically speaking. So you need to register quickly to reserve yourself a seat. And there will be a secret prize draw at the end of the webinar that is very, very worth you sticking around for. I'm not going to tell you what that is, but if you want to know more about how you could benefit from the prize draw just for being on the webinar itself and taking some action, then you need to stick around till the end and you'll see what that is. And then what we're also going to be doing, or certainly what we are contemplating doing over the coming weeks, is introducing a second prize draw to do with social media. I know we've got a few of you on socials right now, so appreciate you joining us and thank you for doing that. Thank you for the likes and the hearts. We appreciate that, but we need more people interacting with us on socials. We really do. So we're looking at driving a social media based prize draw where we can get some virality going. We want likes and we want the hearts while we're on. That's great, but we also want shares. We want this content to be shared amongst your social media followers and people that you are friends with. Most of your friends, most of your family, most of the people that follow you on socials will probably have a mortgage, will probably have a credit card, will probably have some kind of low debt, something that's weighing them down. We have solutions for that here, where they can discharge all of that and redirect the taxes back to where they belong, which is them, which is you, the original creditor. So why would they not want to learn about this? So we'd encourage you to share the content, and we're going to be putting a structure together in terms of how you may also be able to benefit from a very powerful prize draw based on social shares and more people engaging with our content on the ROS Media platform. So keep your eyes peeled for that one and stay tuned. That's coming shortly. That's all I have to say. Any final thoughts before we let everybody go?
And we will be launching an avatar on mortgage discharge and the process. So if you are interested in it and you're thinking, hey, I don't think, I know enough about it, so if that's putting you off from employing the process, then we will launch the avatar and you'll be able to employ Ecclesia Law to do your forensic securitization and mortgage discharge report. You're employing Ecclesia Law to act as your trustee for your foreign grantors trust, for your signature credit redirection. You're employing ROS and the tax department to file your 1099 OID. And you can employ an administrator to actually file your case in District of New York for you, not for you as in your representative, but as your administration agent. So you've got all the bases covered if you are interested in doing this.
Okay. All right. So it doesn't have to be as overwhelming as people may think. We're not expecting them to suddenly be a lawyer and know the ins and outs of everything that's being done. They need to understand it to a certain degree, but we've got all the different resources in place to help and assist with that. Perfect. Well, guys, I hope you've enjoyed it today. Look out for our webinar on Saturday. Like I said, you can go and register for that, and we'll hopefully see you there 10 a.m. sharp Saturday morning. For now, have a great day, and we'll see you next week, same time, for another webinar Q&A. Bye for now.